It's 2:30. So we're welcome to another session of oral argument with the 5th DCA. It is Thursday afternoon, December 16, 2021. Appreciate the attorneys being able to appear by Zoom. I am Judge Lambert. I'll be presiding over this oral argument this afternoon. With me on the panel, you see our judges Eisnagel and Traver. We have one case this afternoon, 21-846, Karen Moody-Alchin, and I apologize if I'm mispronouncing, as personal representative of the estate of Ursula Penland versus Teresa Barton Guardian. We are on YouTube, so please keep that in mind with any comments you make that people are watching and can hear you. If you have any electronic devices or phones or what have you, please either put those in the mute position or turn them off completely so that they don't disturb your opposing counsel or yourself or the panel as we're going through the oral argument. Okay, each side has 20 minutes for argument. You see the clock is it's in my upper left-hand corner as I'm looking at my screen. I will reserve 5 minutes for the appellant unless, Mr. Tyson, you tell me you would like some other time, and then I'll have the keeper of the clock adjust accordingly. I'll try to give you a heads up as you get into your rebuttal time. If you want to keep going, that's fine. If not, stop when you feel you need to. That being said, everybody's ready. Mr. Tyson, Mr. Wilkins. Mr. Tyson, you're the appellant, sir, so you may proceed.
Okay, thank you, judges. May it please the court. I'm Brandon Tyson. Of course, I represent Karen Moody-Alchin, who's a personal representative in the estate of Ursula Penland. And while there's a very long factual history in this case, I think I'm going to try to kind of crystallize the issue that's before the court because it's kind of a straightforward issue. Ms. Moody-Alchin brought a civil lawsuit against the former guardian for breach of fiduciary duty, civil theft, and constructive fraud. There was a motion for summary judgment brought by Ms. Barton, which is the order that's on appeal here. What happened was when Ms. Barton, so originally Ms. Barton was the guardian when Ms. Penland was alive. Ms. Penland passed away in 2013. When Ms. Penland passed away, well, prior to Ms. Penland passing away in 2011, I believe, Ms. Barton, who had served for 16 months and who had received $77,000 in compensation, ultimately resigned in favor of the appellant, Ms. Moody-Alchin. So what Ms. Barton did was she filed a petition for discharge, rather standard as usually is the case. She filed a standard petition for discharge asking that the court approve her distributions of the final assets that were remaining. And there wasn't really many assets remaining. There was a lot of assets in the beginning of the guardianship, upwards of $175,000 in cash. And at the end, there's basically
if I could interrupt you. Can you hear me?
Yes, sir. Yeah.
Okay. It's getting straight to the merits here. I think that your initial argument that, hey, look, our objection did not litigate these issues. That seems like I won't speak for the panel, but to me, that seems like a strong argument. The argument that I'd like for you to maybe flesh out for us is the last argument that you made starting on page 34 of your brief, where you essentially argue that, hey, this isn't a compulsory counterclaim. We didn't have to raise these issues before. And specifically in this entire section, you only cite to one case, the Montanez case. I read that case, and I don't think that's on point. The quote you have appears to be pretty clearly dicta. The court didn't even address that issue. So if you could sort of put some, flesh this out for us with some maybe citations to law as to why can, your client wait years after a court has ordered or has approved certain fees to raise the issue now?
Well, she could wait 3 years.
Hold on. I guess specifically I want to talk about the res judicata issue, though. I mean, I understand there's a statute of limitations, but it seems to me that those two concepts might be different. So as far as res judicata goes, why, if the probate court specifically approved fees at some point, why can you now come back and attack those same fees that the trial court has already expressly approved?
Well, in the particular circumstances of this case, the court approved fees, but in order for res judicata or collateral estoppel to have applied, and I just want to make one real quick point. That wasn't really the basis of the trial court's ruling, but I'm happy to address it because I can address the issue.
Well, if there counsel, it's important for us because of tipsy coachman, correct?
Yeah, I understand that, and so like I said, I'm more than happy and prepared to address that. So the orders that were entered on guardian fees during the course of the guardianship proceedings, there was never evidentiary hearings. There were never testimony that was taken. My client did not get a full and fair opportunity to litigate that issue. And for res judicata or for collateral estoppel, which is related obviously for that doctrine to apply, and in my reply brief, I actually lay out the various elements. There has to be a full and fair opportunity to litigate those issues.
Did your client receive notice?
What happened, Your Honor, is there were hearings, and there was 2 hearings that my client attended. And my client at one hearing objected and asked for additional time. And then the court said, okay, we're going to have a continuance. I can give you the dates of the hearings if you like. But the first time the judge said, okay, we're going to have a continuance and we're going to have the hearing on Ms. Barton's fee petitions heard at another time. There was never a subsequent hearing. What ended up happening on the first fee petition was that same day, the judge entered an order. So there's nothing in the record showing there was an evidentiary hearing. In fact, the court minutes, which were summary judgment evidence that we had presented to the trial court in defense of their motion for summary judgment, showed that there was supposed to be a continuance, and that despite the fact the court ordered a continuance, that they entered the order that same day. I'm trying to get to the part.
Counsel, I guess, just so we utilize all of our time, because I think there's potentially a bunch of issues here that we need to discuss. I mean, that sounds like a really good argument for review of that order that was entered, without sort of an opportunity, right? But that's not the order. You didn't seek review of that order, did you? And that's certainly not the order before us.
That's certainly not the order. That's certainly not the order before us. But the lawsuit that we filed was an action to actually seek and obtain monetary damages and affirmative action from Ms. Barton.
Is it your contention, Mr. Tyson, that you would not have been able to obtain monetary relief against the previous guardian in the guardianship proceeding before it was closed?
Well, the guardianship proceedings never been closed. The guardianship proceeding closed.
Is it your contention? Is it your contention in the context of the discharge process that your client would not have been able to obtain monetary relief against the predecessor guardian?
Not in the course of an objection. What she filed was an objection. Could she theoretically have filed her lawsuit at that time? Theoretically, yes, she could have filed her lawsuit at that time. But the objection, Your Honor.
So let me ask you about that. Sorry for the echo. The possibility that she had to file an adversary proceeding before discharge occurred. How does that factor into our res judicata analysis?
Well, discharge never actually finally occurred until 2021. That was the argument that's in my brief. And so when Judge Eisenhower asked me, about the question bringing up that statute, the statute says there's a 3-year statute of limitation. That's why I'm saying theoretically, by the absolute terms of the statute says 3 years from the date of discharge. The actual date of discharge in this case was 2021. Now, as far as I think your question is, well, could she, when she filed an objection, could she also subsequently thereafter maybe had filed this civil lawsuit? To answer that question, you got to look at what the basis of the objection. The basis of the objection was she wanted documents. She felt that Ms. Barton had a duty as guardian to produce financial records, medical records, things of that nature. And that was the basis of the objection. So from a practical standpoint, it's kind of hard to say, well, could you have filed it? Theoretically, you could have filed it. But there's no, it's like I said, it's not a compulsory counterclaim that you now have to, when you object, you at the same time have to bring a civil action. Because when
Counsel,
you object,
that's one in your brief. You say it's not a compulsory counterclaim, but you cite absolutely no authority and provide no analysis for that proposition.
It goes back to that rule. The rule 5.680 basically says, okay, if somebody files a petition for discharge, you have 30 days to file an objection. Okay, so if it was a compulsory counterclaim, theoretically, you'd have 30 days to file the lawsuit, correct? Okay, so, but 744, 531 says, no, you have 3 years from the date of discharge. So
two things, counsel. I think I think one place where we're maybe missing each other, and maybe you could educate me on this, is it seems to me that a statute of limitations is not the same thing as the doctrine of res judicata. Do you agree with that?
I agree with that, yes.
Okay. So the fact that you're pointing to a statute of limitations to say that res judicata doesn't apply in this case, I'm having a hard time getting a hold of that, of grasping that concept.
Because the objection, there's nothing, I've not seen any case law or a statute or anything that says you have 30 days to file an objection. We know that. That's the rule. There's no issue. I mean, that's plain, text. It seems illogical and sort of impractical to suggest that when during that 30-day period, you now as a successor guardian who wasn't privy to documentation, wasn't even the guardian for a very long period of time, if at all. Sometimes the guardian gets discharged or applies for discharge and then somebody else subsequently gets appointed. It seems it just doesn't make sense to me that in a 30-day window, you now are forced to have to bring a civil lawsuit, which in this case,
I don't know that you would be, counsel. I mean, had your client not abandoned the objection, I don't know that it would have been 30 days, right?
Well, she has 30 days to file the objection, then you have 90 days to call it up
set the hearing. Right.
Set the hearing, correct.
And I think maybe the road that Judge Traber was going down was that didn't your client have an option to, in that same proceeding, to commence a surcharge proceeding against the guardian?
Well, but that's in essence what this civil lawsuit is. The civil lawsuit is basically akin to a surcharge action against a guardian. We're seeking monetary, and at one point I sort of want to bring up is this lawsuit is about more than just guardian fees. It's about other matters other than just the fact that this guardian, charged and received an exorbitant, unreasonable amount of guardian fees. I mean, that's obvious. This case is also about wasteful spending of awards money. It's also about improperly accounting for awards money. It's about improper hiring of agents and other people. She had 22 different people.
Counsel, I apologize. It just seems like this might be an important question. It's something that's been floating around as I've read the briefs in my head. But before the discharge proceeding, long before the discharge proceeding, certain fees and costs and expenses were approved by the probate court, correct?
Some, not all, but yes.
Right, but some were. So as to those fees, costs, expenses that were specifically approved by the probate court by order prior to the discharge proceeding, why wouldn't those be final orders that need to be appealed pursuant to Rule 9.170B21?
Because those orders, the arguments that have been brought in this case, remember that hearing was just Ms. Barton bringing an action to approve her fee. Remember, she already gotten paid. She had gotten this $77,000 and then afterwards brought a motion to the court and said, hey, judge, can you approve my fees? Now, that's the way she did it. So if Miss Moody Alchin wanted to appeal those orders, all those the appeal would have done is said, okay, I'm denying your motion, and therefore, those fees aren't approved. Ms. Moody Alchin still has to bring some sort of affirmative civil action to recoup the fees, also to bring damages for the other transgressions.
Well, couldn't she have recouped the fees by appealing at the time of the order approving those fees?
I don't believe so, because remember that it was a petition by Ms. Barton. You can only appeal what was before the court. What was before the trial court was a petition to approve fees, and the court approved fees that were already paid. And so let's say Ms. Moody Alchin appeals and the appellate court, you guys agree and you reverse the ruling. That doesn't do anything in the sense for Ms. Moody Alchin. She still needs to bring a civil action to recoup the fees. We also
it's a decision, but counsel, that sounds like it would have been a decision on the merits, though. And sure, yes, then how you go and collect would be certainly an additional hurdle. I agree, but at that point, the trial court has ruled on the merits, and then under your hypothetical, the appellate court has reversed.
But remember, the hearing. So I guess your hypothetical is, let's say the appellate court remands it back. Because the issue was there was never a hearing.
Reverses the approval,
okay,
right?
Reverses the approval. So now Ms. Barton has no approval for the fees that she's received. We also, the trial court in this case approved the claim for punitive damages. So,
right, but and I recognize that punitive damages, fraud damages, those things might be a separate issue. I'm talking about just any claim related to, hey, these fees were unreasonable. Not relating to a fraud claim, not relating to punitive damages. Didn't the trial court already decide that?
The trial court decided it, but it's not collateral estoppel and it's not res judicata as to my client, because the collateral estoppel only applies where there was actual litigation between the parties.
What about res judicata?
Res judicata wouldn't apply, because in order for res judicata to apply, there must be an identity of the thing sued for, an identity of the cause of action. The identity here would be the reasonableness of the fees sought by the guardian. But it was filed by Ms. Barton. And remember that one of the arguments in this civil litigation is not only just that the fees were unreasonable, but was the manner in which she ran up the fees. What she was doing was she had 22 different people charging at her $75 an hour rate, even though they were getting paid subsequently less. The evidence by her own admission at the deposition was she had software where she could have, like lawyers do. You have associates.
Yeah. Is that part of your fraud claims? Is that part of your fraud claim?
It's part of both the fraud claim. It's part of both, as well as our fraud claim is that the statements were fraud because she didn't do what we're talking about. It's also part of the breach of fiduciary duty because she, as guardian, had a duty to properly account. And also she had a duty to, if she wanted to hire because she was the guardian, not her company, if she wanted to bring in other people, lawyers, assistants, accountants, whoever, she had to reasonably employ them. And so that's not reasonably employing third parties when you bring them in and you pay them $20 an hour and you bill them out at $75 an hour. I mean, this is
Tyson, you're down to 3 minutes almost. So do you want to save?
Yes, I'd like to, Judge. Thank you. Thanks for reminding me.
All right, very well. All right, Mr. Wilkins, go ahead, sir.
Thank you, Your Honors. May it please the court. It really, I think, the crux of this case is really whether or not she had an opportunity to object to the fees that were awarded by the court. The process in which you get fees approved in a guardianship court is exactly what happened here. A guardian files a petition. There's a hearing set on it. There's notice of the hearing set. If there's an issue about those fees, then any interested party can file an adversary proceeding.
But counsel, that wouldn't apply to things like claims of fraud, though. You agree with that, right?
Well, granted, it wouldn't apply as to claims of fraud, but in this case, I think the undisputed facts are that Ms. Barton specifically disclosed that she was billing her staff at the same rate that she was billing her time as well. And there was no question about that. Miss Moody Alchin admitted she knew that, or she certainly she knew that that staff was being used and her time was being billed. It's only way after the fact that they raised an issue about that, and the judge was aware of that.
What procedural vehicle had Miss Moody Alchin acted with due speed during the objection process would she have used to obtain a monetary judgment against your client?
What she could have done is to file an adversary proceeding in the guardianship, in which
For surcharge?
For surcharge, sure.
Seems to me, and correct me, I've got two questions about that. The first is, just because she could have obtained or could have initiated an adversary proceeding for surcharge, is there anything that you're aware of that requires her to do so? The second question that I would have is that it appears from my reading of surcharge cases that they relate to the exclusive way that you can obtain a monetary judgment against a guardian for fiduciary duty breaches. And I'd like to piggyback on Judge Eisnagel's question because it doesn't seem to say anything about fraud. So the first question is, just because she could do it, how does res judicata trigger? In other words, what authority is there that she had to do it? My second question is, surcharge seems to apply to fiduciary duty and not fraud. And if you could address that.
Well, I think surcharge, first of all, to answer the last question, deals with fraud and any breaches of duty by fiduciary. So it could be fraud. It could be fraud by itself by fiduciary is a breach of fiduciary duty in and of itself. So that's clearly a remedy that could be surcharged. With respect to the question of whether she had to do it, well, she's in front of the court, the petition's in front of the court, the petitioner's in front of the court, the amounts that's being requested is in front of the court. If she thinks those fees are excessive or they're improperly calculated or there's fraud in the petition itself, that's the time in which she can file
Counsel, that. How can fraud claims be res judicata? I mean, but kind of by definition, right? You know, at least some of this, some fraud claims wouldn't even be knowable by the trial judge at the point the trial judge is approving fees.
Well,
right.
The fraud claim arises from, if you look at what she's claiming the fraud claim is, she's claiming that she billed her staff at a higher hourly rate than she should have. That's the fraud. If you look at his complaint, that's what this whole case is about, is the complaint that she billed her staff at her rate. That's not fraudulent if you disclose it. Fraudulent means you misrepresented to the court, misrepresented to the parties about what you're doing.
No, counsel, could I stop you there for a second? I mean, I hear what your argument is. Look, they haven't alleged fraud, right? You're saying they've dressed it up as fraud, but they haven't actually alleged fraud. I'm just asking you a more general question. If it was a bona fide fraud allegation, how could that be res judicata in this circumstance?
Well, I'll have to think about that, but perhaps it's not, because it's not part of what you would normally bring in a review of fees, unless it's clear that that's the basis of the fraud. It seems to me.
Well, what if you didn't know? And I'm kind of, piggybacking on that idea. What if it was an approval based on a widespread nature of fraud perpetrated by a crooked guardian that nobody knew about until a year or two after the discharge? I mean, I struggle to see how you would be required to file a surcharge proceeding and then an unsuccessful one that you didn't know the basis for, and then have res judicata preclusive effects when you learned about the fraud later. You might be saying, in the context of this case, I've got a great motion to dismiss or motion for summary judgment on the civil action because it's not fraud. But I don't know how we would write an opinion. I'd struggle to say, I don't know how we would write an opinion saying categorically fraud has to be raised in the context of approving expenditures. Does that make sense?
It does. It does. I guess my response to that is, if you're trying to craft out of whole cloth a fraud claim, that's essentially what he's done here, given the record in this case. So the adjudications that were made by the trial court at the time of those hearings were never appealed. They were never objected to, except for the very last one, in which the court deemed her objections abandoned. I mean, she alleged in there that there was misapplication and misspending and all kinds of ne'er-do-well doing in her final objection that she abandoned, and that was appealed to this court. And this court
imagine a situation for me where instead of abandoning the objection, she calls it up properly for hearing, and the trial court sustains it. And moreover, she decides, perhaps as a strategy matter, I want this guardianship closed. I don't want this to continue on any further, so I'm not going to object to the discharge. I would rather file my fraud and breach of fiduciary duty claims in a separate circuit court action where she's not arguably going to be taking guardianship money to defend the lawsuit. So it's a strategy call to be able to say, I'd like to do this in a separate legal action. In that scenario, and I guess this circles back to my do you have any authority for it question. Why is she required to file an adversary petition at that particular point in time, as opposed to seeing out the closure of the guardianship and filing a separate civil action?
I think the overarching construct of both the guardianship statute and the probate statute, because they're basically governed by the same sets of rules. The whole construct is that basically you're on an accelerated pace when you deal with these types of issues. You're on an accelerated pace for guardianship. When you file objections, you've got to call them up. You've got to move these things along quickly. You can't just lay in the weeds and decide you can bring these things years after the fact. I mean, here we are, we're 10 years after the fact when all of this is going on, and here we still are. Those kinds of adjudications, because it's important for the ward's welfare of the time, it's important for the guardian to know she's got some finality. Those things need to be dealt with at the time. And if you, I don't think you can review the guardianship rules and the guardianship statute as giving an inordinate amount of time for folks to bring their objections to the court and have them resolved. And that's what she just, if you allow her to go back now, you've essentially allowed her to lay in the weeds, which she had all these opportunities to bring these things up at the time in front of the court. When she was there, she was present with counsel. She did some of these objections as the guardian. So she's basically saying, I didn't have to do them as a guardian, now I can do them as the personal representative of the estate. And I just think that the whole construct of the probate and guardianship rules really suggests that is not appropriate behavior.
I agree with you that there's a lot, especially as it relates to the objection process. There's a lot of finite time periods, especially in the rules. Are you aware of any statute or rule, or case for that matter, that says that there is a requirement to bring an adversary proceeding?
Well, I think the rule itself says that if you have objections to the discharge of the guardian, you have to bring those objections to the court within 30 days of the petition that's filed by the guardian. They filed their objection timely in this case, but then they didn't ever call it up for hearing. So to me, that ends the inquiry. The guardianship rules basically cut her off for those objections, as well as I think any objections that she could have brought at the time that she didn't bring. And in that particular objection, I think it's clear that she was complaining about the spending of the money and the fees. I mean, that's what the whole objection was about. If she
Counsel,
really
if I could, and I think there's two potential time periods here, and we've talked a lot about the discharge proceeding. I'm not yet convinced that the discharge proceeding is the proceeding we should be looking at, or the order we should be looking at. Why, but long before the discharge proceeding, it looks like the probate court approved at least some of the expenses of the guardian fees, etc. Why aren't those specific orders, when the guardian comes and says, probate court, please approve these specific fees. Here's what I did. Here they are. And the probate court enters an order approving those fees or expenses. Why is that not an appealable order under 9.170B21?
It absolutely is. It absolutely is.
But counsel, if that is the case, then why are we spending so much time talking about the discharge proceeding? Why isn't it raised judicata when that order is entered?
Well, I think it is. I think that was my argument. If you look at my motion for summary judgment, that's essentially the argument we made primarily in the summary judgment petition. We basically said that you've got 3 orders that were entered by the court, 3 orders that are appealable under that appellate rule that you just referenced. And they didn't appeal them. Nobody appealed them. And as a result of their failure to appeal those findings and those orders, they're barred from ever appealing those orders. And so
your specific position then is that an interim order approving, let's say, the first request for guardianship fees, for that, if you are you're the appellant in this case, at that time, way back in 2010 or whenever this was occurring, if she was unhappy with that award, that she had a right to appeal that at that time, even though the guardianship case is still ongoing and we don't know what's going to happen with Miss Barton?
Absolutely, or otherwise it wouldn't be in the rule to allow them an appeal for those kinds of orders. That's an appealable order. They amended the appellate rules some years ago. The probate and trust law section requested that change in the rule because this kind of stuff was basically allowed to just kind of drag on. And
well, following up Judge Eisenhower's question, these earlier orders, how many orders were there that approved guardian fees?
3.
When was the first one?
The first one was entered on the first petition was filed November 2nd, 2010, and the order was entered on January 5th, 2011. The second petition was filed on July 7, 2011, and the order was entered on September 9th, 2011. And the third one was filed on October 8, 2012, and the order was entered on March 26, 2014.
Well, let me ask this 9.170. Did it become effective January 1, 2012?
I can't tell you exactly when it became, but that I know that's the rule that existed at the time. It exists now. If that's when it became effective.
Well, but I mean, then if there was no specific rule authorizing was there a separate rule before? Let's assume that's the right date. If I'm looking at the rule book correctly. Those orders then wouldn't be appealable on the first 2 orders, at least wouldn't, under your view, wouldn't be appealable under this rule because it didn't exist.
Well, right. That's the question. It couldn't be appealable under this rule, whether it could be appealable under normal
counsel, that 9.170 references final orders of a probate court and then has that long list, but doesn't it expressly say that it's not an exhaustive list?
It does.
I mean, the way I read the rule is it's simply saying, hey, we have this concept of final orders, and now we're going to list a whole bunch of them.
I think that's why they
that doesn't make the order less final before the rule was promulgated, right?
I would agree. I think that rule was intended really as a clarification because there was a lot of confusion as to what you could appeal and what you couldn't appeal.
So you're saying even before this rule, then you're saying any interim order that awarded guardian fees was immediately appealable.
Could be appealed. Absolutely. I believe it could have been.
Okay. Go ahead.
But essentially, I think the issue here is really comes down to whether we've got any appeal of those 3 orders. The answer is no. Whether or not when we filed the final accounting and the final accounting disclosed those fees, and those objections were made and abandoned and appealed and lost on appeal, I think that basically ends the case. The fraud that seems to be the focus today, to me, I agree with your suggestion that it really is subject to a motion to dismiss on the grounds that the record contradicts that because it was disclosed and how you have fraud when it was disclosed. But keep in mind, he's also claiming that it was fraud and setting up the pooled income trust, the pooled assets trust to try to qualify for Medicaid. That too was approved by the court after a hearing in which his client was present. And he never raised any objections to it. It's only after the fact when it turns out that she didn't live long enough to really get a lot of benefit out of Medicaid.
Let me ask you a follow-up question from
Sure.
what Chief Judge Lambert was asking, just so I understand your position about the interim orders. So go with the 2014 one, because it doesn't seem like there's any issue about rule applicability potentially for that. Is it your contention that if you do not object to that, that a later adversary proceeding in the same guardianship case for surcharge would be barred by res judicata because you didn't
Yes.
object?
Yes. That would be my position, absolutely.
So
And let me-
so essentially the bright line rule that you're advocating for is that if you do not object, or if you object and don't win on appeal, that any further action relating to tort claims is barred.
I would agree with that, unless it's something that wasn't encompassed by the, by the order and the matter under review. Here, those things were reviewed. The fees are what we were talking about. That's the whole point of the review. And let me.
In other words, but counsel, a bona fide fraud claim wouldn't fit into that category, right? Of something that the trial court reviewed. I mean, not most of the time anyway.
But what did the court not review here? That's the question. The court did review the fees, it reviewed the pooled income trust, it reviewed the expenses. Those are all the things he say are the fraud. The court reviewed all of those things. And that was the subject of the appeal that was affirmed by this court because she didn't pursue any of those objections in a timely manner. And the other thing too, let's go back to just the pooled income trust here for a second. I don't want to overlook the point that because the court approved the transfer of all of the liquid assets of the ward into that pooled income trust, at that point in time, if the fees had been disallowed and returned for Miss Penland to be able to continue qualified for Medicaid, those fees would have had to go back to the trustee of that pooled trust. That's who has suffered any damages. That's who would have suffered damages for any fraud. And they're not even before the court. And that, again, was not appealed. That contract with the pooled trust was approved by the court. That provision is in there. And so I don't know how you get from allowing the estate to recover assets for the benefit of apparently Miss Moody Alchin. Although, by the way, we've got a bunch of legal fees that are going to get paid first before those things happen. We've got a
Counsel,
yeah.
Not focusing on discharge, but focusing on the orders that actually approved specific fees and expenses. As to those orders, would you agree that the only way res judicata would apply to those determinations would be if the fraud claim was actually raised and litigated at the time of the order?
No, I would not agree with that.
Okay, explain that to me.
Well, I think if you had the opportunity to discover the claim, or there is no concealment of the issue that you're complaining about, then I think you have to raise it at the time. I think that would be
so if the guardian sort of files a report saying this is a fraudulent report, please grant my fees, then res judicata would apply.
Yes, I mean, if you said yeah, it's a fraudulent report, but in this case it's not. There's no citation to anything that suggested that this was somehow fraudulent by her having her staff bill. That's been done for years in Orange County, not just with my client, but with other guardians as well. There's nothing in the statute that says you can't do that. And again, because a lot of these professional guardians do have competent staff, they bill at those rates.
Okay.
I guess I'm at the end.
Any other questions? Anybody? Okay. All right. Thank you, Mr. Wilkins.
Thank you.
All right, Mr. Tyson, looks like you have a little over 3 minutes to go.
All right, thank you, judges. I want to go back because I know Judge Straver, Judge Eisnagel have spent a lot of time talking about the interim orders that were entered on the attorney's fees petitions. And I want to explain to the court specifically the procedure of what happened, because the procedure to me is exactly dispositive of this issue. The Guardian from August 2010 to June 2012, she received $77,000, okay? She already received the money. Then after she received the money, she files a petition to award her $40,000 that she had already received, okay? And Ms. Moody Alchin attended a hearing. The hearing lasted 14 minutes. There were no witnesses, no evidence was presented. The hearing was to be continued and heard on a separate date. And in spite of that continuance, an order was entered on that same date granting the fees petition. So what happened was Ms. Barton brings an affirmative action. I'm not understanding how Ms. Moody Alchin was required in defending that action, which she never fully was able to defend, was to bring a separate civil action that not only challenged the amount of the fees.
How about appeal that order? How about appeal that? Was that order ever appealed?
That order was never appealed because appealing that order was only one piece of the pie. That there's so many things that went wrong in this case that Ms. Barton did wrong. The pooled trust, for example, I'll give you an example. Yes, it was approved. And so the thought of the purpose of approving the pooled trust was that it was going to conserve Ms. Penland's money if she got on Medicaid. Well, what ended up happening was $77,000 got put into this trust, and Ms. Barton, within a month or two, took $55,000 of them. So yes, the court approved the pooled trust, just like a court approves a sale of a property. So it was Ms. Barton's usage, how she went about utilizing that pooled trust, which was designed to protect Ms. Penland's assets for Medicaid, so she would have the proper care. She didn't utilize it in that manner. She utilized it in a manner for her own self-benefit, because she took all the money from the trust, basically. Also, part of this is that she left the ward by all her spending, not just on her own fees, but all the spending that she did on behalf of Ms. Penland, basically left Ms. Penland without any money. I mean, at the end of the guardianship, she had $400 in liquid assets. So this case is a lot more than just about the fact that a judge determined part of her fees. And then the second hearing they had in 2014 on fees, after Ms. Penland's passed, they come back in after she dies and try to get prior fees approved, which is procedurally incorrect. The judge, again, without a hearing, without testimony, without evidence, cut the fee in half. I think it was Judge Mihawk who cut the fee in half. So I know I'm out of time, Your Honors, but I think that's the point, is that's just an isolated incident in a whole long history of transgressions that Ms. Barton has done in this case.
But it seems like some of the theme, though, that you're hearing from the panel is, okay, when these hearings, these orders are entered inappropriately and you have a remedy by direct appealing at that time and you don't, how can you then come back later and say, well, I'm going to bring a separate civil action to get damages for all that mischief that occurred along the way that I was observing happen to me, but I didn't take an appeal, or I lost the appeal if I appeal?
Because the doctrine that governs whether, so the issue is when those orders on attorney's fees are entered and the court said, okay, these fees are reasonable, that's a factual determination that was made. Okay, and so if you want to then challenge a factual determination, again, that would mean collateral estoppel would apply. The elements of collateral estoppel do not apply in this case because Ms. Moody Alchin never litigated and had a fair opportunity to litigate. So
but isn't that what you raised? As saying, hey, I'm appealing this. Look, it was a 14-minute hearing. I had witnesses ready to go to say this is an excessive amount of fees, it's inappropriate, et cetera, and I didn't get my chance, so my due process rights are violated. Appellate court, please correct this, and let's go back and have a fair evidentiary dispute or a fight or hearing about it.
Yeah.
I mean, I think that's what that seems to be the concern.
And let me answer. I'm sorry. Let me answer that directly. So if like I said, I may have made this argument earlier, but if she appealed at the time and was successful on the appeal, remember, This is Ms. Barton trying to get approval of her fees. Ms. Moody Alchin, this case is about trying to recoup money from Ms. Barton. So if the appellate court reversed it and said we didn't, your petition for fees were should have been denied, or you get a new hearing, Ms. Moody Alchin still left with the same need to bring a civil action. That's the point.
But counsel, at that point, there's no, the determination on the merits has been overruled, has been reversed by the appellate court. So you wouldn't have res judicata problems, right?
I'm sorry, ask that again.
But my point is, yes, you still then would need to claw back the money. Yes, in the real world, I get that. But you would have removed the res judicata issue because you would have an appellate court reversing the trial court's determination on the merits of reasonableness.
Well, there probably would have had to been a new hearing. So if we appealed, if Ms. Moody Alchin appealed it on the basis, like Judge Lambert said, 14-minute hearing, yada, yada, due process, and the appellate court agrees, then there'd have to be a new hearing.
Right.
Okay. All right, counsel. All right. Thank you both. We'll take this under advisement. That'll conclude our oral argument for today. Appreciate it.
Thank you, everyone.
Have a good day.